Morning, everyone. Call this special meeting to order, and I would please ask Jennifer to take a roll call.
Yes, sir. Joanne Adams.
Here.
Claire Batt.
Here.
Holly Bloodworth. Mike Bowling. Alvis Johnson.
Here.
David Karam.
Here.
Patrice McCrary.
Here.
Cody Polly Johnson. Sharon Porter Robinson.
Here.
Lee Todd.
Here.
Lou Young.
Here.
Jacqueline Coleman. Aaron Thompson. Allison Sloan.
Here.
You have quorum.
Thank you very much. The next item for the Kentucky Board of Education discussion may require this board to go into a closed session pursuant to KRS 61.8101J and KRS 61.815 for the deliberation by the Kentucky Board of Education regarding the adjudication of River Cities Academy Incorporated versus Newport Independent Board of Education, action number 20, BOE-001, as required by KRS 157.350. Do I have a motion to go into closed session?
So moved.
Joanne has moved.
Second.
And Lou has seconded that. Any discussion? All those in favor signify by saying aye.
Aye.
All those opposed? The ayes have it. We are now going to go in closed session, and we ask those folks who are not to be in the room to please vacate. Having concluded our confidential closed session pursuant to KRS 61.8101J and KRS 61.815 for deliberation by the Kentucky Board of Education regarding the adjudication of River Cities Academy Incorporated versus Newport Independent Board of Education, action number 20, BOE-001, as required by KRS 157.350. We are now returning to the open session portion of this public meeting. The Open Meetings Act prohibits a body like the Kentucky Board of Education from taking any action in the closed session of a public meeting. The Kentucky Board of Education did not take any action during the closed session meeting. I'm going to now declare a recess of the Board of Education until 11:30, and at 11:30 we will reconvene to take up action on this issue. So we are now in recess till 11:30. The meeting of the Kentucky Board of Education will come back to order. We have asked, after deliberations, for Counsel Todd Allen to present a proposed final order. Todd, if you would please present that.
Yes, sir. So based on the pleadings filed and the board's deliberation, we've drafted the following for your consideration that I'll read into the record. Final order. This matter came before the Kentucky Board of Education by appeal of River Cities Academy, Inc., known as Appellant, pursuant to 701 KAR 8030, following the denial of the appellant's charter school application by the Newport Independent Board of Education, known as Appellee. The Kentucky Board of Education, being sufficiently advised, hereby renders the following findings and final order. Factual and procedural background. On June 29, 2017, Kentucky's public charter school legislation became law and was codified in KRS 160.1590 through 160.1599. At that time, the appellee became a public charter school authorizer charged with reviewing, approving, and denying charter applications and processing the authority pursuant to KRS 160.15944A to only approve applications from charter applicants, quote, that possess competence in all elements of the application requirements, end quote. During the 2017 regular session of the Kentucky General Assembly, The legislature also passed House Bill 471, which amended the 2016 to 2018 executive branch budget to, among other items, provide a funding mechanism for public charter schools. That legislation required a local school district wherein a public charter school was situated to, quote, transfer the public charter school's portion of the local school district's funding calculated pursuant to KRS 157.360, end quote, and to allocate such, quote, in the same manner as the school allocation model used by the local school district based on applicable data provided by the public charter school, end quote. However, this funding mechanism expired on June 30, 2018, and is no longer law in Kentucky. And, to date, no legislative action has been undertaken to reinstitute House Bill 471 language or provide another alternative funding mechanism for public charter schools in the state. 4 administrative regulations promulgated by the Kentucky Board of Education became effective on March 9, 2018 that implement Kentucky's public charter school legislation and address the following. 701 KAR 8010 Charter School Student Application Lottery and Enrollment. 701 KAR 8020 Evaluation of Charter School Authorizers. 701 KAR 8030 Charter School Appeals Process, and 701 KAR 8040 Conversion Charter School Petition Conversion and Operation. Most relevant to this appeal is 701 KAR 8030, establishing the process to appeal a public charter school authorizer's decision to deny a charter application and incorporating the notice of appeal form required for submission of an appeal to the Kentucky Board of Education. On October 30, 2019, Lynn Shaber and Evelyn Pence, acting on behalf of the appellant, filed a Kentucky charter school application and addendum, known as Charter School Application or Application, with the appellee. This document totaled 939 pages and proposed, quote, a K-8 urban community charter school targeting a diverse learner population, end quote, from, quote, 6 local districts, end quote, including the appellee, as well as Covington Independent School District, Bellevue Independent School District, Dayton Independent School District, Ludlow Independent School District, and Fort Thomas Independent School District. Although no specific school facility location was cited by the appellant, the application did state, quote, the founders have selected Newport, Kentucky as the target location located in the middle of the 6 river cities, end quote. In accordance with KRS 160.15943E and Appellee's Board Policy 01.911, the appellee notified the appellant of deficiencies in the appellant's charter school application on December 6, 2019, and, at that time, granted the appellant a maximum of 10 calendar days to provide additional materials and or amend its charter application to address identified deficiencies. Related to this notice, the appellee received supplemental communications from the appellant on December 9, 2019. The appellee conducted an in-person interview pursuant to KRS 160.15943B with the appellant on December 17, 2019, and the following day, on December 18, 2019, held a public forum to allow local residents to become familiar with the charter school application and provide feedback in accordance with KRS 160.15943C. As required by KRS 160.15943A, the appellee engaged in a review of the appellant's charter school application and, to do so, assembled a panel of 31 individuals with combined experience related to finance, transportation, food services, curriculum and instruction, special education services, and school leadership. These educators and stakeholders evaluated the application against the appellee's chosen rubric and on December 23, 2019, recommended the appellee deny the appellant's application due to the application's cover sheet and enrollment projection being deemed partially complete. Furthermore, the panel recommended denial of appellant's application because the following 6 components of the appellant's charter school application were judged does not meet: school overview, education program design and capacity, operations plan and capacity, financial plan and capacity, closure and dissolution, and optional information. Pursuant to KRS 160-15945, requiring public charter school authorizers to adopt by resolution all charter approval or denial decisions in an open meeting within 60 days following the filing of the charter application, the appellee adopted in a public meeting held on December 26, 2019, a resolution stating, quote, "Now therefore be it resolved by the Newport Independent Schools Board of Education that the Newport Independent Schools Board of Education has denied the River Cities Academy charter application submitted by Lynn Shaber and Evelyn Pence." On January 23, 2020, the appellant appealed the denial of its charter school application and, pursuant to 701 KAR 8030, filed the notice of appeal form with the Kentucky Board of Education. Therein, the appellant acknowledged this appeal is the first notice of appeal to the board on this authorizer decision and waived its right to a hearing before the Kentucky Board of Education. On January 28, 2020, a notice of appeal and briefing schedule was served by U.S. first-class mail and email to the appellant and appellee. Subsequently, the appellant filed its brief in support of its appeal prior to the deadline of 4:30 p.m. on February 5, 2020, and the appellee filed its responsive brief in support of its position prior to the deadline of 4:30 p.m. on February 12, 2020. By mutual agreement of the parties, the appellant was permitted to and did file a reply to the appellee's brief prior to the deadline of 4:30 p.m. on February 17, 2020. At a public meeting on February 25, 2020, the Kentucky Board of Education met to decide upon the written pleadings and, at that time, adopted this final order. Burden of proof and standard of review. The Kentucky Board of Education, pursuant to KRS 160-1593A, shall review the decision of the authorizer and make its findings. The board is to review the decision of the appellee to determine if the authorizer's decision was contrary to the best interest of the students or community. The appellant, as they are the party opposing that the appellee takes a certain action, bears the burden of proof in this appeal. Quote, "In all administrative hearings, unless otherwise provided by statute or federal law, the party proposing the agency take action or grant a benefit has the burden to show the propriety of the agency action or entitlement to the benefit sought." End quote. As such, the appellant bears the burden of proof to show that the authorizer's decision was contrary to the best interest of the students or community. The decision of the appellee denying the application will be reviewed in the following manner. Factual findings will not be set aside unless they are clearly erroneous. Factual findings are not clearly erroneous if they are supported by substantial evidence, which constitutes evidence having the fitness to induce a belief in the minds of reasonable people. The Kentucky Board of Education will review the appellee's application of the laws and regulations at issue de novo, that is, if the appellee correctly applied the law and regulations to the factual determinations contained in their decision. Analysis. Paragraph 1. The appellant's financial plan and capacity. A. Attachment 25 of the appellant's charter school application includes a 5-year budget that includes a startup year and 4 years of charter school operation. During the startup year, the budget shows that the appellant projects a deficit of $529,957. B. The appellant's budget proposes paying down the projected shortfall in its startup year over time using revenue from grants and fundraising. The 4-year operational projections rely heavily on public funds for the majority of funding in each year of the budget and makes assumptions about receiving public funds based on a student average daily attendance allocation. The appellant asserts that in the first fiscal year of operation, it will receive $186,916 of public funds per month from July to June for a total of $2,242,994. The budget also predicts revenue from charter school grants totaling $225,000, a local transportation allocation of $42,009, federal and state grants in the amount of $150,000, and $75,000 in direct contributions. In total, the budget assumes $2,735,003 of total revenue and $2,636,635 in total expenses. C. In subsequent years of the budget, the appellant's reliance on public funds for the majority of its charter school revenues continue. Specifically, in fiscal year 21-22, the appellant assumes total revenue of $2,722,498, including $2,230,719 from public funding, and total expenditures of $2,652,483. In fiscal year 22-23, the appellant assumes $2,998,815 in total revenues, including $2,673,739 from public funding and $2,992,461 in total expenditures. In fiscal year 23-24, the appellant assumes $3,400,132 in total revenues, including $3,116,758 from public funds and $3,344,389 in total expenditures. And in fiscal year 24-25, the appellant assumes $3,635,453 in total revenues, including $3,347,753 from public funds and $3,536,566 in total expenditures. D. KRS 160-15933 requires a charter school application include, among other items, a proposed 5-year budget, including the startup year and projections for 4 additional years with clearly stated assumptions, and a detailed startup plan, including financing, tasks, timelines, and individuals responsible for carrying out the plan. Further, KRS 160-15947B says that an application shall be approved if, among other items, the applicant demonstrates the ability to operate the school in an educationally and fiscally sound manner. E. While the appellant has provided, as required by KRS 160-15933G, a proposed 5-year budget, including the startup year and projections for 4 additional years with clearly stated assumptions, the assumptions within the 5-year budget are wrongly premised on the appellant receiving public funding. The appellant's budget assumes that the majority of its funding will come from public funds through an ADA allocation. However, under Kentucky law, there is no such current funding formula for public charter schools. F. Pursuant to KRS 157.330, the Support Education Excellence in Kentucky funding formula is the primary source of allocating the majority of public funds to school districts. SEEK provides funding to districts using a formula based on student adjusted average daily attendance. However, this funding does not currently extend to public charter schools. The application is unclear as to whether these are the public funds contemplated. Further, as noted in subsection B above, other funding sources projected by the appellant include, for example, federal and state grant funding, as well as direct contributions. However, the appellant does not include within its charter school application evidence of securing such grant and donor funding. Thus, the appellant has not demonstrated the ability to operate in a fiscally sound manner pursuant to KRS 156-15947B, and its budget is built on financially unsound assumptions regarding the receipt of public and private funds necessary to sustain its public charter school. H. In the reply brief of the appellant declines to address the funding concerns raised in the brief of appellee and only says, quote, the reason RCA did not mention funding in its pleading was simply because it was not highlighted by the board as a major concern, end quote. However, the appellant was on notice of the finance-related concerns its charter school application presented, as the appellant's charter school application was judged does not meet in the area of financial plan and capacity, as well as 5 other application components. Additionally, KRS 160.5501 prohibits a local school district superintendent from recommending and prohibits a local board of education from knowingly approving an expenditure in excess of the income and revenue for any year, except in very limited circumstances. While KRS 160.15921 generally exempts public charter schools from all statutes and administrative regulations applicable to a local school district, subsection 3H of that same statute requires a public charter school to adhere to all generally accepted accounting principles and adhere to the same financial audits, audit procedures, and audit requirements as are applied to other public schools. Further, pursuant to KRS 160.15923P4, a public charter school may only incur debt in reasonable anticipation of the receipt of public or private funds. J. The appellant's projected deficit of $529,957 during its startup year does not adhere to generally accepted accounting principles as required by KRS 160.15923H and is prohibited under KRS 160.15923P4. and it is not in reasonable anticipation of the receipt of funds. As noted above in subsection E, the appellant's budget assumes that the majority of its funding, including funding needed to repay the deficit incurred during its startup year, will come from public funds. However, such an assumption is inconsistent with Kentucky law regarding allocation of public school funds as set forth more fully in subsections E and F above. Further, additional funding sources cited by the appellant in its application are not supported by evidence demonstrating that the appellant would be eligible for such grant and donor funding or that it has been secured. K. KRS 160.15941E1 requires a public charter school authorizer decline to approve a charter school application that fails to meet the requirements of KRS 160.1593, including the requirement in subsection 3 for a charter school application include a proposed 5-year budget, including the startup year and projections for 4 additional years with clearly stated assumptions, and a detailed startup plan including financing, tasks, timelines, and individuals responsible for carrying out the plan. Furthermore, KRS 160.1594 requires, in subsection 7b, that an application be approved when, quote, the applicant demonstrates the ability to operate the school in an educationally and physically sound manner, end quote. KRS 160.15944A grants an authorizer the discretion to authorize a charter school application only if that application demonstrates, quote, competence in all elements of the application requirements, end quote. L. Based upon the Kentucky Board of Education's determination that the appellant's charter school application is deficient in the area of financial plan and capacity, the appellant's application fails to meet the requirements of KRS 160.1593 and 160.1594 and lacks competence in all elements of the application requirements as required by KRS 160.15944A. In light of these insufficiencies, the appellee was legally barred from authorizing the appellant's application, and accordingly neither erred in its denial of the appellant's charter school application nor acted contrary to the best interest of the students or community under KRS 160.1595. Authorizing appellant's application for the operation of a charter school when appellant's projected revenue to operate the school is premised on receipt of public funds it will not actually receive is contrary to the best interest of students in the community. To authorize such a charter application would ignore the fact that appellant's proposed school is not financially sustainable. 2. Other components of the appellant's application. Pursuant to KRS 160.1594 1EL, and 4A, the demonstrated deficiency in the financial plan and capacity component of the appellant's charter school application is determinative of this appeal in favor of the appellee, and the Kentucky Board of Education declines to issue any additional analysis or findings related to the applicant's charter school application or the appellee's analysis thereof. 3. The appellee's deficiencies raised by the appellant. A. The appellant asserts that the appellee failed to comply with its authorizer duties on several occasions, including 1. Failing to show in accordance with KRS 160.15943E Number 1, failing to allow, in accordance with KRS 160.15943E, the appellant a reasonable time to provide additional materials and amendments to its application to address any deficiencies. 2, failing to properly publish in accordance with 701 KAR 8030 Section 2 policies and procedures, including a rubric for its evaluation of a charter application. And 3, failing to meaningfully comply with KRS 160.15943C, which requires an opportunity in a public forum for local residents to provide input and learn about the charter application. B. Pursuant to KRS 160.15941E1 and 4A, the demonstrated deficiency in the financial plan and capacity component of the appellant's charter school application is determinative of this appeal in favor of the appellee, and the Kentucky Board of Education declines to issue findings related to the appellee's compliance with its authorizer duties. Even if the appellee were to have relied upon deficient policies and procedures in its processing of the appellant's charter school application, issues of procedural noncompliance would not negate the fact that the appellee was legally barred from authorizing the appellant's application and accordingly neither erred in its denial of the appellant's charter school application nor acted contrary to the best interest of students or community under KRS 160.1595. The appellant also states one of the forces spurring efforts such as this has been the long-standing, unresolved issues that have faced the Newport Independent Schools District. The appellant continues by citing improvement priorities found during a turnaround audit that the appellee underwent during the 18-19 school year pursuant to KRS 160.346 as well as 703 KAR 5280. The appellant's charter school application clearly states that it is for a startup charter school and not a conversion charter school. The performance of a district or its schools is not a prerequisite to or justification for the establishment of a startup charter school. Furthermore, the Kentucky Board of Education found that the appellee was legally barred from authorizing the appellant's application and, accordingly, neither erred in its denial of the appellant's charter school application nor acted contrary to the best interest of students or the community under 160.1595. As such, it is not necessary for the Kentucky Board of Education to consider the performance of the appellee or the schools it presently governs in this appeal. Number 4, the appellee's bias raised by the appellant. A, the appellant states, from the start, the authorizer's approach has been heavily biased against RCA. The appellant also states the overall lack of engagement of the board when they were charged to lead the review process brings into question just how seriously they took RCA's application to begin with. The appellant provides instances in which perceived bias and apathy was evident, including statements made at the public forum held pursuant to KRS 160.15943C on December 18, 2019, as well as the lack of interaction between the appellant and the appellee at various times throughout the application process. Further, in the reply brief of the appellant alleges, quote, in its pleading, the board does not refute RCA's concerns of bias in the process as outlined in RCA's notice of appeal, end quote. B, pursuant to KRS 160.15941E1 and 4A, the demonstrated deficiency in the financial plan and capacity component of the appellant's charter school application is determinative of this appeal in favor of the appellee, and the Kentucky Board of Education declines to issue findings related to allegations of bias raised by the appellant. A de novo review, that is, a review independent of any alleged bias or apathy of the appellee's application of laws and regulations governing this matter leads the Kentucky Board of Education to find that the appellee was legally barred from authorizing the appellant's application and, accordingly, neither erred in its denial of the appellant's charter school application nor acted contrary to the best interest of the students or community under KRS 160.1595. Conclusion. The Kentucky Board of Education has determined that the authorizer's decision was not contrary to the best interest of the students or community under KRS 160.1595 and accordingly upholds the decision of the appellee to deny the Kentucky Charter School application and addendum filed by the appellant. So ordered this 25th day of February 2020.
Thank you very much. To bring this before us, we will need a motion to approve this draft of a final order. And I will entertain a motion from Sharon, a second from Claire. Now we have an opportunity for discussion. Is there anyone on board who wants to make a comment? Wait, Lou.
Thank you.
Lou. I looked at Lee and said, Lou.
Lou, right. Thank you. I just have a very quick comment I'd like to make, and that's first to thank all the parties involved today, including River Cities Academy and the Newport Independent Board of Education. I know that none of you take this process for granted, nor have you taken it lightly. I also really wanted to thank Commissioner Brown, Mr. Allen, with exemplary reading aloud skills, and the members of the KBE staff that sat with us through the closed session. I really appreciated the thoroughness and attentiveness of their responses today, Commissioner, and the opportunity to hear questions and concerns that we raised, which included the appeal in its entirety, but I found it especially instructive and helpful to be able to delve into the financial plan so that we could examine these preeminent issues related to funding deficiencies on the part of the River Cities application, and as noted in the detail and order. And then lastly, to you guys, thank you so much. I always appreciate the serious, thoughtful, and rigorous way you approach these decisions, so just wanted to get some gratitude on the table.
Any other questions or comments? Then the question is on the adoption of this final order. The motion's been made, properly seconded. All those in favor signify by saying aye.
Aye.
Opposed? The ayes have it. The next order of business is, unless there isn't some other matter, the next order of business is adjournment. And Alvis, would you be willing to make a motion to adjourn?
I certainly would.
Thank you very much. And Patrice has seconded that. All the aye?
Aye.
All those opposed? The ayes have it. We are adjourned.